Good afternoon. I'm Michelle Peak, and I'm happy to welcome you to this year's CLE session. And this session today will be Norton Rose Fulbright, and it will be in-house counsel issues dealing with any type of bankruptcy risk. And we will welcome both of our folks remote today, and we are especially grateful to our sponsors, all of them today, but in particular, Norton Rose Fulbright, for their continued support to our chapter, especially during last year's symposium adjustments. We first have Rebecca Winthrop. She has a diverse practice, primarily representing creditors in the financial restructuring and insolvency proceedings. She represents financial institutions, special servicers, and other secured creditors, both in and out of court. Her experience ranges from handling voluntary liquidations and assignments for the benefit of creditors to negotiating and documenting debtor in possession and exit financing, use of cash collateral, lift, stay proceedings, and planned treatment in complex Chapter 11 bankruptcies. She also represents purchasers of distressed assets and unsecured creditors in a variety of industries, including healthcare, manufacturing, real estate, and entertainment. We welcome you, Ms. Rebecca. Next, we also have on the panel Ryan Mans. Ryan joined Norton Rose Fulbright in 2003. Throughout his career, Ryan has represented a variety of clients, both inside and outside of court, in different stages of business restructuring, involving transactional and litigation-related engagements. Ryan frequently advises public and private corporations, board of directors, management teams, creditor and acquirers of financially distressed assets in complex business restructuring matters. He has experience in a variety of industries, including energy, media, healthcare, real estate, and construction. We welcome both Ryan and Rebecca.
Thanks so much, Michelle, and thank you to everyone for joining us today. As some of you all are aware, last year was a record year for bankruptcy filings nationwide due to all the collateral damage associated with COVID. Now that the economy is reopening, we have not seen as much activity as we saw last year, but there are still pockets of distress in certain industries. Our goal with this presentation is to provide you with an overview of the bankruptcy process, as well as to highlight ways that you can proactively manage your company's risk when dealing with a distressed counterparty. We would like to make this presentation as interactive as possible. As Michelle mentioned, to the extent that you have any questions, please submit them via the chat function, and we will do our best to answer them during the course of our program. With that, we'll go ahead and move to the next slide. So we'll start with just the most common types of bankruptcies that you might see, beginning with Chapter 7s and Chapter 11s. While we'll focus on these bankruptcies in more detail in the upcoming slides, we'll just present a quick overview right here. Chapter 7 cases are for individuals and businesses. They are liquidations as opposed to reorganizations. Generally, there are no operating assets in a Chapter 7 case. In a Chapter 7 case, a Chapter 7 trustee is randomly appointed from a panel to administer the liquidation of estate assets. Generally, in Chapter 7s, there is little to no recovery for unsecured creditors. And that's important to understand going in as you assess potential risk and strategies going forward. Some cases don't even require the filing of a proof of claim because there might be a no asset Chapter 7 case. That's much different than a Chapter 11 case where you either have a reorganization, a sale, or a liquidation. Chapter 11 cases deal with individuals and businesses. Again, they can be liquidations or reorganizations. Typically, a debtor stays in possession and control of its assets during a Chapter 11 case, although there are rare instances where a Chapter 11 trustee is appointed to administer the estate's assets. The goal of a Chapter 11 is to rehabilitate a business as a going concern and restructure a company's debt so that it may emerge from bankruptcy as a viable, ongoing entity. Next slide, please. So what are the primary benefits of bankruptcies? First off, the automatic stay is a primary benefit. It's one of the most fundamental protections afforded to a bankrupt debtor. The stay is a statutory injunction imposed immediately upon the commencement of a bankruptcy filing. It provides a debtor with a breathing spell from its creditors. Once a creditor receives a notice of a bankruptcy filing, all collection actions must cease. This means that phone calls, demand letters, or emails to the debtor demanding payment are all prohibited. Similarly, filing lawsuits against the debtor or continuing prosecution of lawsuits that were already filed is prohibited. This includes private arbitration. Additionally, creditors are prohibited from setting off any debt owing to the debtor against any claims against the debtor, absent a court order. Creditor actions taken in violation of the automatic stay are punishable by that creditor being held in contempt of court.
Let me just jump in here real quick, Ryan. There's been a couple of decisions out of the Supreme Court as well as the Ninth Circuit, which is my home jurisdiction, whereby they show that they've been serious about punishing creditors for violating the automatic stay. There's one case out here where the bank repeatedly violated the automatic stay and sought to take enforcement actions, and the bank was punished by $50 million in punitive damages. They are serious. So please, the first practice tip is please communicate with your accounting department. Tell them about the bankruptcy. Once you've got a notice coming across your desk, immediately alert everyone involved in the relationship and let them know. A good faith belief is not a defense. Being stupid is not a defense. So when in doubt, research, or frankly, call Ryan or myself. We'd be happy to help you figure out whether you can take certain actions.
Thanks, Rebecca. Great point. Next slide, please. So the absolute priority rule dictates the distribution waterfall in bankruptcy. It mandates that secured creditors get the value of their collateral, and then unencumbered assets are divided by priority. First, you have administrative expenses, expenses incurred in the ongoing administration of the estate. That's to vendors or professionals or the like. Second, you have statutory priority claims. Third, you have all your general unsecured creditor claims. And then last, you have equity interests. Typically, in most Chapter 11 cases, or Chapter 7 cases for that matter, equity interests get wiped out in bankruptcy. Next slide, please.
So
I'll turn it over.
Go ahead. I'm sorry.
I was going to turn it over to you to handle the managing counterparty risks.
We wanted to focus first on the front end before bankruptcy even starts, to kind of give you some practice tips on what to look for as you sense that things are not going well with some of your counterparty relationships. Of course, and the first point is from the start, and it bears repeating, conduct due diligence on your contract counterparty. I had a hospital client that had hired one of a major doctor to head up one of its practices without doing that background check, and found out, had they known, they would have found out that he had a history of suing the hospital for breaching his physician services agreement. And lo and behold, that's exactly what they did with us. So take the time at the front end to do that due diligence. And then the step two, of course, is as you're starting to see these relationships turn, monitor your significant relationships. Never underestimate the power of a Google alert. I've got several going. I've used them throughout my career, and it's astounding what you can find out via what pops up via Google alert. Look for negative news, earning releases, M&A activity. Is there an oddball sale of asset? Do you see them unloading a piece of property, a real estate that you knew that they had a distribution center? Maybe that distribution center is really important to the flow of goods to your organization. Anything to indicate what's going on with that company. There's also public filings, of course, is a fabulous, SEC filings is a fabulous way to get information. And if you are working with an entity that is a public entity, hospital district, that kind of thing, think about EMMA. EMMA stands for Electronic Municipal Market Access. It's a free website and it's official source for municipal securities disclosures and related market data. They have to give notice public entities have to give notice of material adverse changes on this website. So it is a great relationship, a great place to find a good information about your your contract counterparty. Next slide, please. So if money is owed to your company, what additional things should you be thinking about? I'm not talking about a traditional banking relationship, just a vendor that perhaps you've extended credit. Again, look for warning signs. If you're in a joint venture, and again, this has happened to me, you may be getting you may be getting information through your joint venture relationship. Read that information. Warn your business partners to pay attention to those information that comes across the board. You're thinking, oh, this is really basic stuff. It's not. I cannot tell you how many clients have said, oh yeah, I didn't read that financial reporting. So again, look for aging in accounts receivables, weak inventory turnover, change in executive leadership or outside professionals. CPA firm, all of a sudden, if they change CPA firms, that could be because, of course, the CPA firm couldn't give them the audited financial statement that they were looking for. Next slide. So if you sense that things are starting to really take a turn for the worse because you have been actively monitoring your credit relationships or your vendor relationships, again, pretty basic stuff, but do it. Gather all that the related contractual agreements, documentations, amendments, make sure you can find them and make sure they're signed. I cannot tell you how many clients have come to them and said, okay, where's the agreement? And they're like, can't find it, or they've only got a draft, or maybe it's dumped in somebody's email basket, but they can't put their hands on a signed agreement. Take a look at those agreements as you sense things are going south. Take a look at those contractual rights and remedies. Understand what your notice periods are. If you've only got a 30-day notice period, then you know you've got to work much farther out than you ever thought of. What are your termination rights? And then if you were lucky enough to get a secured interest in a piece of collateral, take a look to see if you have properly perfected that security interest. Have you got the UCCs on file that you want? Is it a fixture filing? If it isn't there, maybe you scurry around and file it anyway, with the hope that things don't go into bankruptcy and then you perfect it. Just scour, take a look at what's going on in the file and make sure you understand where you can find things. Next slide. So if things are going south and you do have an opportunity to negotiate an agreement or renegotiate the agreement and you've sensed that bankruptcy is definitely on the horizon, what are a couple of things that you should be thinking about as you consider that renegotiation of the agreement? First of all, think about your ipso facto clauses. So what is that? It's a provision which permits termination due to bankruptcy, insolvency, or the financial condition of a party. Now, it's not enforceable if the company actually goes into bankruptcy, but in today's world with a ton of PPE loans, many companies are not going into bankruptcy, and so when in doubt, throw it in and hope they don't file. They could also change the law, pretty basic stuff, but you never know. Also consider alternatives to ipso facto clauses. So can you get to the same place without hitting over the head with the idea of, if the company goes into bankruptcy, then you get to terminate your agreement? Is there a financial covenant? Is there some other metric, reporting obligations, some other metric that you could put in your termination provisions that allows you to, in essence, as you sense bankruptcy is coming, that you could pull and not trip over the ipso facto prohibition in a bankruptcy case? Similarly, if you sense bankruptcy is right around the corner, give them a short period. Have tight timelines so that you can pull those triggers before they go into bankruptcy. Are there any rights and remedies that you could improve? Could you ask for additional security, like a letter of credit? Now, if they're having financial problems, most likely they're not going to have anything else to offer you, but you never know. You might as well ask. Is there a third-party guarantee that you could ask for? And then finally, if the contract is expiring, maybe you just let it go. Or maybe you let it go and say, okay, I'm going to give you that same agreement, but I'm going to shorten it from a 3-year term to a 6-month term, or even month to month, or God forbid, invoice only. All of these are practical solutions to when you sense bankruptcy is around the corner. Next slide. So this is my favorite slide. It's like, oh my God, I actually got the actual notice of filing for bankruptcy. Ryan, tell me what to do. Next slide.
Will do, Rebecca. Thank you. So Chapter 11, as we touched on before, the code is designed to provide a debtor and its creditors a mechanism for dealing with the debtor's financial difficulties. It does this by providing the debtor and its creditors with a web of checks and balances that serve the dual purpose of protecting the parties and creating a framework for achieving a consensus on a multitude of issues. The intended culmination of Chapter 11 is to give the debtor a fresh start through the binding effect of the order confirming the plan of reorganization. If reorganization is not feasible, a sale of substantially all the debtor's assets or an orderly liquidation of the estate's assets are possible outcomes. A Chapter 11 case is commenced by the filing of a bankruptcy petition. It can also be commenced by the filing of an involuntary petition by one or more of the company's creditors. Most debtors file Chapter 11 where they are domiciled or where their primary place of business is located. Over the last year, the Southern District of Texas and Delaware have been the most popular filing venues in the country. Candidly, most debtors attempt to file in venues where they perceive to have debtor-friendly and predictable judges. The filing of a bankruptcy case creates a bankruptcy estate comprised of all property and rights of the debtor. Next slide, please. So once a case is filed, there are a number of first day motions that are typically filed. And again, this is in a large Chapter 11 case. First day pleadings they cover both administrative, operational, and substantive matters. The administrative matters involve joint administration, notice procedures. The operational motions entail cash management, critical vendors, utilities, employee benefits, and wages. And then the more substantive motions deal with both cash collateral, debt financing issues, and/or contract and lease rejection. The relief sought in first day motions are extremely important that they can substantially affect your company's rights as creditors. And so those motions should be carefully reviewed.
So it will literally be in some of these large cases, it'll be 3 inches of paper coming across your desk. And it can be, not only can it, as Ryan said, negatively affect your rights or significantly affect your rights, but it also can be a great source of information about what's going on with the company, what's going on with the industry, what are the company's plans for the future. So it is a great resource and is definitely worth the time to plow through all the pages.
Yeah, and I'll just add to that the declaration in support of the first day motions is a very important pleading to review because, again, it provides some more history on the company. It talks about what led to the filing of the bankruptcy case, and it also hopefully provides some insights as to the direction of the debtor in bankruptcy. What's their exit strategy? Are they attempting to reorganize? Are they going to pursue a sale? How do they plan to exit bankruptcy and maximize recoveries to creditors? Next slide, please. So this next slide focuses on the major milestones in a Chapter 11 case. Once the case is filed and the debtor holds its first day hearings, the debtor is also required to file its statement of financial affairs and schedules of assets and liabilities. The debtor will also file its top 20 creditors list. The United States trustee uses the top 20 creditors list to form the Committee of Unsecured Creditors. Shortly after the case is filed, there will be a 341 meeting of creditors that is held. That's an opportunity for creditors of the company to ask questions of a debtor's representative under oath. Another important deadline or milestone in the case is the proof of claim deadline. it's important to file your proof of claim to the extent that the scheduled amount is inaccurate, because that preserves your rights. It preserves your rights going forward to whatever amount that you're owed. Again, once a case is filed, the goal of the debtor is to stabilize the operations of the company, and they can do that through cash collateral and debt financing, and also through some of the administrative motions that we've talked about. Successful Chapter 11 cases culminate with the filing of a plan of reorganization or liquidation. A plan is a multi-party contract between a debtor and all of its creditors, specifying how the debtor's outstanding obligations to his creditors will be restructured through the bankruptcy. It also addresses what will be the source of any repayments that are being made and the form, if any, the debtor will take after bankruptcy. Any plan proposed by the debtor will be put to a vote by various classes of creditors and equity security holders and must receive approval by the bankruptcy court before it will bind the debtor's creditors going forward. Next slide, please. So this next slide addresses the major players in a bankruptcy case. We've talked a little bit about the debtor, and the debtor typically has both not only legal professionals, but also financial advisors to assist it through the case. Of course, the bankruptcy judge is a prominent player in any case. The committee is really the primary fiduciary that guides the unsecured creditors through the case. They retain professionals, both legal and financial advisors. The United States trustee is the government watchdog that's involved in every case. A Chapter 11 trustee or examiner only appear in cases on rare circumstances where there is some kind of concerns about fraud or mismanagement by the debtor. And then, of course, you have lenders and other secured creditors that play prominent roles as well. Employees can potentially play a prominent role in a bankruptcy case to the extent that CBAs are an issue in the case. And then again, depending on the case, you have regulatory agencies that are very involved. Again, if we're talking about a potential sale of the company, you'll have buyers that are involved in the case, and they could play a major role in the case as well. And then, as we touched on earlier, a Chapter 7 trustee will be appointed in Chapter 7 cases.
And I like to call bankruptcy, and this will drive all the litigators nuts. In a litigation, you got A versus B. That's all there is. In a bankruptcy, as you can see, you've got 10 different groups of people. And it's like it's like that show, The Game of Thrones. Alliances are formed, and then they shift, and then they form again. So it's all about finding who your friends are, who your enemies are, and lining up to be groups of people that advance your particular agenda. So it moves fast, and it's multifaceted. But also, as you know, people think of bankruptcy as a negative event. It can be a really positive thing for you. It can be a business opportunity. If you know the industry that the debtor is operating in, they will be selling assets. It could be a great place for you to pick up an important asset relatively inexpensively if you know what you're doing and you can move fast. These sales of assets can frequently occur on 30 days notice, so you're going to have to move fast, but you also could get a bargain basement price. So it can be a great opportunity for you. Next slide.
So we talked about the committee really quickly earlier. And again, once a case is filed, the United States trustee will seek to form a creditors committee that is comprised of the debtor's creditors. Even if you do not have an interest in serving in this capacity as a committee member, all unsecured creditors can still benefit from the guidance of the committee, who is appointed to voice unsecured creditor concerns. Again, the committee is a fiduciary of the estate. Their goal and objective is to maximize the recovery for unsecured creditors. Typically, after a case is filed, a United States trustee will hold a formation meeting. The U.S. trustee will interview certain committee or prospective committee members. A committee will be formed if there is enough interest to sit on the committee, and it usually consists of up to 7 unsecured creditors. Typically, we see committees that are formed with 3 to 5 creditors, depending on interest. Fees for the committee are importantly paid by the estate. And then the official duties, again, include consulting with the debtor throughout the case in regard to administration of the case, reviewing and advising the court of the committee's position on material motions or other legal actions. And the committee is also charged with investigating the debtor's pre-petition conduct for potential or possible causes of action against insiders that would benefit the estate. Next slide, please.
So we've been talking a lot about Chapter 11. What happens in a Chapter 7? First of all, it started just like any other Chapter 11 case, but the sole purpose for the most part is to liquidate the debtor's assets and do it as fast as possible. The automatic stay takes effect immediately, just like in a Chapter 11. And as we talked about, Chapter 7, trustee is appointed to administer the assets, or abandon, which is basically after determination that the assets have no value, that will float down to unsecured creditors, and then he will abandon them, that's the buzzword, abandon them back to the debtor. There's only two key events in pretty much in a Chapter 7 case. One is a 341A meeting that we've talked about, and two is the bar date for filing proofs of claim. Next slide. So as a creditor, what should you be watching for? First of all, we've talked a lot about the 341A meeting. It's a chance for free discovery. Debtor is put under oath and has to answer questions put to them by the Chapter 7 trustee focused on where are the assets, why they filed for bankruptcy. 2 is whether or not you need to file a proof of claim. 3 is making a reclamation demand or asserting a 503B9 claim, which if you've provided goods, you may have to exercise certain rights to get those goods back, and you may have to do them within a very short period of time. As if you got lucky enough to have collateral, you may want to think about lifting the automatic stay so that you could get out from underneath the bankruptcy, the effect of the bankruptcy, and go off to exercise your rights under state law, such as foreclosure. And then finally, the other main event that may happen is defending against litigation claims by the trustee, such as preferences and avoidance action. And that's where your biggest exposure is going to come in as a creditor in a Chapter 7 is the Chapter 7 trustee may want to sue you for returning any amounts that you were paid within 90 days of the bankruptcy, which is called a preference. And why is there so much focus on litigation? It's because these Chapter 7 cases are usually administered by the trustee for a grand total of $60. The way he makes his money and covers his costs of administration is he's looking for things to sell because he can get up to 3%, and avoidance actions or actions that he can assert against creditors because he gets up to 3% of those actions as well. So it's a completely different business model than a Chapter 11. Next slide. So I like to use this slide as your, whoops, sorry, that's my reminder. I'd like to use this slide as a checklist of the things you need to think about when you are a creditor. These are the 5 things that we're going to talk about during this call. You should put on this list reclamation rights if you're providing goods, and any other UCC rights you may have under state law. But that's the things you need to think about it for the most part when you see a bankruptcy come across your desk. Next slide. So let's talk about the first one. Filing a proof of claim. This is what the form looks like. Pretty basic. Next slide. So what is a proof of claim? It's a written statement. It notifies everyone what you feel is the amount of money that you are entitled to receive from the debtor. In a Chapter 11 case, all creditors generally have the right to file a proof of claim, but it should not be a plug and crank immediate, oh yes, of course, a bar date has been set, I need to file a proof of claim, because it submits you to the jurisdiction of the court, the bankruptcy court, and you may not want to be there. Mind you, if you don't file a proof of claim, you won't get any distributions, but it's something you need to think about before you just blindly fill out that form. What is the usual deadline for filing a proof of claim? It can arise fairly quickly, 90 days. In large cases, they may not set it for a while. They may give you much longer. They can also shorten if the case is moving fast. You need to look for anything that says notice of bar date. That's a magic deadline. That is a magic notice and a magic deadline by which you need to file this proof of claim. proof of claim basically submits all the information, who you are, which debtor you are filing your proof of claim against. Lots of times I recently handled a hospital case where there were 140 different debtors, and you have to figure out against which debtors you have a proof of your claim is against. And then finally, most importantly, it is signed under penalty of perjury. I never file a proof of claim on behalf of my client. So you need to make sure the person filing the proof of claim understands this is filed under penalty of perjury and is punishable by fines of up to $500,000 and imprisonment up to 5 years or both. These people are serious about filing proof of claim. Next slide.
So with critical vendors, we typically see these types of motions in your mid-level to large Chapter 11 cases. Again, in these cases, the argument in favor of critical vendor payments is that it is likely that payment of pre-petition claims of certain vendors will benefit all creditors because this payment will allow a debtor's business to avoid a likely loss or to gain a likely economic advantage that is disproportionate to the amount of such vendor's pre-petition claim. Pros of accepting critical vendor treatment include the vendor receives an expedited payment of all or most of its unsecured pre-petition claim. Also, the vendor has the opportunity to negotiate other desirable terms, for example, negotiation of future delivery terms or possible waiver on preference action or fraudulent transfer actions. Ultimately, critical vendor treatment should translate to reduced administrative and legal costs via settlement of all or a significant portion of an unsecured claim. I've only seen a critical vendor creditor decline payment in one instance in 18 years of practicing, and I still don't know why they did it. And the rule of thumb here is if you have a chance to be selected or designated as a critical vendor, you want to do everything you can to move forward on that basis so you can get paid all or substantially all of your claim pre-petition. As for the cons of being selected as a critical vendors must generally agree to continue doing post-petition business with the debtor under normal or less favorable pre-bankruptcy terms. Because vendors must continue to supply goods and services, there is a risk of post-petition non-payment, and this risk increases if the case converts to a Chapter 7. And then lastly, critical vendor payments received are subject to disgorgement and or clawback if the vendor later refuses to continue to supply goods or services in compliance with the critical vendor order and terms. Next slide, please. So unexpired leases and executory contracts are another significant issue in cases. They're a vital component of any case, really, and the debtor's ability to assume or reject its executory contracts or expired leases is a big part of its path forward in a case. This decision to assume or reject is driven by the debtor's business judgment. An executory contract is one in which material obligations continue to exist on both sides of the contractual relationship. Examples include long-term supply contracts in which one party is obligated to continue to supply and the other is obligated to receive and pay for certain goods or services. Next slide, please. So rejection under Bankruptcy Code Section 365, again, this is based on the debtor's business judgment that the contract is a burden to the estate. That rejection results in a breach of the contract, but is not an automatic termination of the contract or lease. Those rejection damages are treated as a pre-petition unsecured claim. Assumption under Section 365 requires the debtor to cure all existing monetary defaults and to provide adequate assurance of future performance. If the debtor assumes your contract, there is no preference liability. Except with respect to certain kinds of contracts, for example, non-residential real property leases, the debtor has until plan confirmation to decide whether to assume or reject your contract. One thing I want to note too, that there are certain ipso facto clauses involved in certain contracts that are unenforceable. And as a practical point, it's important to review all sale pleadings in bankruptcy cases if you are a party in interest in a case, because contracts or leases that the debtor seeks to assume or reject are often buried in the exhibits to a sale motion. If the debtor is assuming your contract, they may have included the wrong cure amount, and the cure amount is the amount that you're owed by the debtor to make you whole. And if they've rejected your contract or lease, you will need to file a rejection damages claim by the established rejection damages claim bar date.
When you get notice of a sale, figure they're sending it to you for a reason. And if you've got a contract with the debtor, that's why. So keep looking for where you're mentioned, because you will frequently have, maybe 5 days sometimes to respond and say, no, 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 I'm owed far more than the 0 that they usually put down for you.
Yeah, and your claim or your cure cost can be buried in, hundreds of pages of schedules attached to an APA. And so it's paramount not to just not to overlook anything in some of the pleadings that are noticed to you. With that, we'll turn it over to Rebecca to address administrative claims on the next slide.
So this is the next area of importance to you as a creditor with a contract, with a contract party who's gone into bankruptcy. So first of all, what is an administrative claim? Obligations incurred by the debtor after the bankruptcy are filed are given priority treatment. So they are paid ahead of unsecured creditors. So usually those obligations are anything that is the actual and necessary cost and expense to preserve the bankruptcy estate. An example is wages, salaries, lawyers, accountants, anything that the debtor is using to operate its business on a go-forward basis in bankruptcy. And the bankruptcy code also entitles, because they want to entice you to, the non-debtor party, to continue to do business with the debtor. So these post-petition ordinary course type of businesses are paid in the ordinary course. So if you're a landlord, they're supposed to go back and start paying you your rent, those types of things. If they're using something that you have, they usually have to pay for it. So why is it important to be an administrative creditor? 3 reasons. 1, administrative, as I've mentioned, administrative creditors are paid first ahead of general unsecured creditors. Always a good position to be in. 2, they have to be paid in full before general unsecured trade creditors, unless the administrative claimant agrees to take a different payout period. And 3, a plan of reorganization cannot be confirmed in a Chapter 11 case unless admins are paid in full. So it is really good to be an administrative creditor. And if there's a way to hook yourself into that status, you should take advantage of it. Next slide. I wanted to highlight a special type of administrative claim, and that's what's called a 503(b)(9) administrative claim. And that permits you to assert an administrative claim for the value of goods received by the debtor within 20 days before the bankruptcy. So if you sold the debtor goods in the ordinary course that were delivered to the debtor within 20 days of the bankruptcy, you get treated, you get to assert an administrative claim and get paid when administrative creditors are being paid. So always think about whether you can track and prove that your goods were delivered within 20 days before the bankruptcy. Unlike a reclamation demand, you don't need to send out a special notice to assert those rights, but frequently courts will set deadlines to assert those claims, and those that deadline may be buried in the court's own local rules, or the debtor may set a special deadline for that, a special bar date. So again, all the more reason to read what's coming across your desk, looking for special deadlines, and talking to your lawyer, bankruptcy lawyer, about how the bankruptcy can affect your rights. Next slide.
So next, let's move on to the debtors or the trustees' avoidance powers. The Bankruptcy Code provides representatives of an estate with multiple avoidance actions. And these avoidance actions are litigation tools that can be used to unwind or recover the value of certain pre-petition transactions that deprive the estate of value that would otherwise be distributable to creditors. In addition to providing these federal law-based tools for challenging improper transactions, the code also gives the bankruptcy estate access to any state law remedies that would be available to creditors generally, rather than causes of action unique to a particular creditor. These provisions of the code have the effect of granting the estate the exclusive authority to prosecute actions to unwind transactions that could benefit creditors generally. The 2 primary avoidable transfers are preferential transfers, and fraudulent transfers. Next slide, please. So a preference action is designed to unwind transactions made shortly before the bankruptcy that would allow the preferred creditor receiving the payment to recover more than it would have through the bankruptcy case. Importantly, no wrongdoing is required for liability. The elements of a preference is any payment made by a debtor to or for the benefit of a creditor for or on account of a pre-existing debt while the debtor was insolvent on or within 90 days before the bankruptcy filing, or if you're an insider, 1 year, and that enables the creditor to receive more than such creditor would receive under a Chapter 7 bankruptcy. The debtor is presumed to be insolvent on or before the 90 days preceding the bankruptcy filing. As a practical point, preference litigation rarely results in a trial, mainly because in most instances, it is cost prohibitive to litigate preference actions. Oftentimes, the parties will negotiate the merits of a cause of action and arrive at a settlement that amounts to a fraction of the amount in controversy. Next slide, please. Well, there are 9 affirmative defenses to preference actions. The most commonly utilized defenses are the contemporaneous exchange defense, the ordinary course of business defense, and the new value defense. With the new value defense, a creditor that has received an otherwise preferential transfer, but thereafter extends new value, has the ability to reduce the amount of its preference liability by the amount of the new value. In other words, if a preferential payment is received and the transferee subsequently delivers new value, for example, goods, that new value will reduce or offset the preference exposure. As for contemporaneous exchange, the transfer may not be avoided if it was intended by the debtor and creditor to be and was in fact a contemporaneous exchange for new value to the debtor. Examples of new value include COD payments. Next slide, please. The ordinary course of business defense is more fact intensive. The transfer may not be avoided if the transfer was either 1, made in the ordinary course of business of the debtor and transferee's relationship, or 2, made according to ordinary business terms. Again, this defense is heavily litigated. Courts will look to the history between the parties and will consider, among other factors, the length of the parties' relationship, whether the method of payments remain constant, whether there were any unusual collection efforts by the creditor, and how the current payment terms differ, if any, from prior payment terms. Typically in this litigation, industry standard requires evidence from a retained expert. Next slide, please. So this next slide speaks to just best practices to reduce your potential preference exposure. When dealing with the distressed counterparty, you will want to be proactive from the outset of the relationship. You want to require full prepayment if possible, or cash in advance. This eliminates the antecedent debt, or you can conduct your business on a COD basis. I mean, ideally, you'd want to obtain a deposit or a letter of credit or other form of security sufficient to cover your company's entire exposure. While these defenses and alternatives for risk minimization may prove successful in a preference defense, this does not mean that the debtor will not send a demand letter and or initiate an adversary proceeding. And a debtor will often send a demand letter or file a lawsuit prior to analyzing any of the defenses we've talked about. This is why you should never turn down a payment. Always take the money irrespective of any preference risk. It's better to address potential exposure on the back end. Next slide, please. Oops, go ahead.
And this is, we go to the next slide. So this is where you also need to be best friends with your accounting department. When you get that demand letter in there, take the time to put together your defenses, because and lay out the ordinary course defense. The date the invoice was sent out, the date it was received, the payment was received, the amount of the payment, that you can track it to the particular invoice. Because what I'll frequently do is I'll spend more money as your counsel at the front end to lay out a nice pretty chart that explains, hopefully in excruciating persuasive detail, what a great ordinary course defense or a great new value defense it is. All of that means your accounting department has to be able to track those payments. and give me that factual information. So it's really important to have those records be maintained in a reliable basis.
Great point, Rebecca. Next slide, please. As we think through other considerations, you should ask yourself whether the trustee conducted reasonable due diligence before initiating a lawsuit. You should also look at transfers from the debtor that exceeds. You should assess whether or not the transfers exceed $6,825 for business debt. Otherwise, the debtor or trustee cannot bring the lawsuit. The trustee must file any lawsuit in your district if preference exposure is less than $13,650. The lawsuit generally must be brought the later of 2 years after the bankruptcy filing or 1 year after the appointment of a trustee. Ideally, the estate will reach out to you prior to commencing a lawsuit, although this does not always happen. Next slide, please. And now we'll turn it over to Rebecca to walk us through fraudulent transfer risk.
All right, next slide, please. So the other type of avoidance action that you could see come across your desk is fraudulent conveyances or fraudulent transfers. And there are two types of fraudulent transfers: actual fraudulent transfers and constructive fraudulent transfers, which is the most common type. Actual fraudulent transfers are committed when the transfer is made with the intent to hinder, delay, or defraud a creditor. There's a very high burden of proof. You need to show intent by the debtor, and the insolvency of the debtor is irrelevant. So usually you see this in the smaller cases where somebody's deeding over, doing a quick claim deed of their house to their grandmother or something like that. Or you could see some insider actions where insiders are trying to secrete assets away from the corporation. Not done a lot, but they are out there. The more common type is this constructive fraudulent transfer, and that is committed when the debtor receives less than reasonably equivalent value in exchange for the transfer, and the debtor is insolvent as of the date of the transfer or became insolvent as a result of the transfer. And typically you may see this if a bank comes in and they demand to pay off, and it basically wipes out a lot of the value of the debtor and leaves behind a corporate shell, something along those lines. Or if, again, the insiders are trying to transfer all the assets away from the liabilities into a new entity, thinking that's somehow going to shed them of the obligations. Next slide. So where else will you see these things come up? If a subsidiary pays for the goods or services received by the parent, what if the subsidiary guarantees the parent obligation? Think about it. How is the subsidiary benefiting because the parent gets a benefit? All of the obligation is staying at the subsidiary level and all the benefits being realized by the parent level. Again, not beneficial to the subsidiary. Acquiring assets from the distressed entity in a non-foreclosure situation. In other words, you got a great deal, but did you get too good of a deal? It could be undone, claiming that you paid too little for the assets. Or finally, taking extra collateral. If someone says, if you continue to do business with me, I'll give you something as collateral that you didn't have before. Like preferences, you take the money, you take the collateral and hold your breath and hope nobody sues you. Next slide. Next slide. Great. So what are the primary defenses for fraudulent conveyances? Challenge the elements of the claim itself. If you're accused of actual fraudulent conveyance or transfer, no intent. If you're accused of constructive fraudulent conveyance, did you get reasonably equivalent? Debtor wasn't insolvent at the time the transfer was made, or the transfer was made beyond the time period permitted by the code section. Did you receive the payments in good faith and gave value in return? That's a defense. And finally, statute of limitations. Fraudulent conveyance action usually has to be brought within 2 years of the bankruptcy filing. Next slide. And finally, how do you minimize your fraudulent transfer risk if you're dealing with one of these types of transactions? First, pay fair price, get a valuation. At the time you do the transfer, collect the evidence, demonstrate that you paid reasonably equivalent value of whatever you bought from a troubled entity. Get the payment from another entity that's solvent. Remember, solvency of the debtor, of the paying entity is the required obligation. We talked about obtain an independent appraisal of the property, again, to demonstrate new value. And last but not least, get reps and warranties from the debtor, outlining the factual predicates of your defense, that they're not doing it to defraud creditors, that there's a valid justification of the transfer, and hopefully that it really is a solvent entity. So with that, we're concluding our program. We are almost out of time. Happy to take any questions. We just want to express our appreciation for your time and listening us today, and we hope our contact information is on the last page of the presentation. And always feel comfortable reaching out to us. Happy to chat with you off just on a casual basis. There are a lot of concepts here, and bankruptcy can be a confusing place, and but it can also be a land of opportunity.
Thank you, everybody, for your time.